Good afternoon. I'm David Lyle, Acting Executive Director of the American Constitution Society. As our nation prepares for the historic inauguration of President-elect Obama, ACS, together with the NAACP Legal Defense Fund, MALDEF, and the Constitutional Accountability Center, is pleased to welcome you to this event, The Road from Lincoln to Obama, the Constitution, and the New Birth of Freedom. Our speakers will address, the questions our speakers will address today are both older than the Constitution itself and as relevant today as they have ever been. For what was the new birth of freedom that the emancipator Lincoln promised at Gettysburg, but the renewal and expansion of the slaveholder Jefferson's audacious and profoundly ironic pronouncement in the Declaration of Independence that all men are equal and possessed of inalienable rights? And they remain the issues that we and President Obama will grapple with in the coming years in contexts neither Jefferson nor Lincoln could have imagined. What is equality? What rights does our Constitution protect, and for whom? The answers can be found in the text, history, structure, and purpose of the 13th, 14th, and 15th Amendments to the Constitution, the New Birth Amendments, which transformed a document defiled by its embrace of racism and slavery into a charter for freedom. To paraphrase William Faulkner, our constitutional past is not dead, it isn't even past, and yet it fails to us to determine the future. We are so pleased to co-sponsor this event with NAACP, LDF, and MALDEF, leading civil rights organizations that have shaped our nation's history, and each a strong reminder that recently founded progressive legal organizations stand on the shoulders of giants. And the Constitutional Accountability Center, an important new organization dedicated to reclaiming the progressive text and history of the Constitution. We are thrilled to have the leaders of our co-sponsoring organizations, as well as two of America's leading historians on today's panel, and we thank each panelist for participating. In addition, I'd like to thank those from each co-sponsor who worked behind the scenes to make this event happen. Debo Adegbile and Monique Briz-Walker of LDF, Laura Rodriguez of the Rabin Group, Olivia Paniagua of MALDEF, and David Gans and Rachel Souter of CAC. I think I would also be remiss if I did not recognize, among many distinguished guests who joined us today, one of the true heroes of the ongoing struggle for civil rights in our country, the Honorable William T. Coleman. I'd now like to introduce Dr. Mary Frances Berry, the moderator of today's panel and also a pillar of the civil rights community, who has made groundbreaking contributions in both public service and academia. To mention a few of her many achievements, Dr. Berry is the Geraldine R. Siegel Professor of American Social Thought and Professor of History at the University of Pennsylvania, past president of the Organization of American Historians, and a longtime member of the U.S. Commission on Civil Rights. And, as we were reminded just yesterday, by her works and her enemies shall we know her. Please join me in welcoming Dr. Berry.
Thank you very much. Welcome. And today I have to tell you that even though I am black, I am not bitter here today. I'm bitter some of the time, but not here. And I would tell you what the guy who made the comment sent me in an email last night in a supposed apology, which is even funnier, but I won't take up the time. Let me just say that this is a momentous event, and we are very grateful that we have these experts here to talk to us about reclaiming the Constitution, the 14th Amendment. And we have agreed that we will have brief introductory remarks from each person, and then we will have some questions back and forth, some discussion, and then questions from you. But let me just say one other thing, is that I have a new book which will be out at the end of the month from Alfred Knopf, called And Justice for All the United States Commission on Civil Rights and the Continuing Struggle for Freedom in America, with 93 photographs of various ordinary people who came over the years since 1957 before the Commission. And it is the story not of the bureaucracy, but of the people who came, who struggled, and how they made the Commission respond to their needs, and how the Civil Rights Commission worked with civil rights advocates. I had this book with me last weekend at a meeting that Wade Henderson had down in New Orleans with a bunch of folks, and had the book, and everybody I showed it to wanted to look in the index first to see if they were in it. Some of you are in it. First, we are going to begin with the history, of course, which is where we must begin if we are to learn anything at all, in my opinion. And therefore, we have Eric Foner, who is one of the most distinguished of American historians, who is DeWitt Clinton Professor of History at Columbia University. And he's going to tell us about where these amendments came from and the anti-slavery tradition that grew out of that era, and Congress's historically broad concept of equality and rights. And then after that, John Payton, who is the CEO, Director Counsel, President, and all things important at the NAACP Legal Defense Fund, after years being a litigation partner and manager in one of the major law firms here in town, following in the distinguished tradition of Thurgood Marshall. And you have bios on all of these people, so I'm not going to read the entire bios because it would take me too long. We'd be here forever. And he will talk about the 14th and 15th Amendments and how they, in fact, were used earlier and what happened to corrupt them. Then we have John Tresvigna, who is the President and General Counsel of MALDEF. And he is going to talk about immigration issues and the 14th Amendment and citizenship rights that are related to that. And then we are going to have Doug Kendall, who is the founder and president of the Constitutional Accountability Center and is also the mother of Miracle. His little girl is quite wonderful. And I see her all the time when I go out running in the morning past their house, and she and I have great conversations. Anyway, and he has the enviable or unenviable task of trying to reclaim the Privileges and Immunities Clause of the 14th Amendment, and assures us that in the next 2 years, the Supreme Court will overturn the slaughterhouse cases and restore the Privileges and Immunities Clause to its pristine purity. So we will begin with Professor Foner.
Okay, I think we're supposed to speak from the chairs here, so I will not go up to the podium. But thank you, Mary Berry, and I'm very, very happy to be here. Following in Professor Berry's footsteps, I want to draw your attention to something I've just written. But it's just an article. But since it's very relevant to what we're talking about today, it's in the current issue of The Nation magazine, and it's an article about Lincoln. And there's a lot of baloney being floated around about Lincoln nowadays, particularly in the popular press. If you want to really understand Lincoln, the evolution of his thought, his views on race, slavery, how they changed, take a look at this article. That's all. But Lincoln we should begin with Lincoln and the new birth of freedom, even though Lincoln obviously was no longer living when the 14th and 15th Amendments were added to the Constitution, because his own, and by the way, let me just ask Professor Berry, I've written so much about this era that I can talk forever, so after I'm gone for about 5 minutes, just nudge my elbow, okay, so I can stop.
Oh, okay.
All right. You know, the thing I think that is interesting about Lincoln in this context, and is really epigrammatic of the whole era of the Civil War Reconstruction, this great crisis out of which the 14th Amendment and really a new Constitution emerged, is the way he was able to change over time. The Lincoln of 1865 was a very, very different man than even the one who entered the Civil War 4 years earlier in terms of his views about slavery, race, equality, etc. In 1862, Lincoln said to Congress, to deal with this tremendous crisis, we must disenthrall ourselves. A wonderful word that you wouldn't hear politicians using today. You know, it's a little too complicated. Disenthrall ourselves. That is, we have to abandon our old ideas and think anew. And in a way, we're in that same situation today. We're in a kind of a crisis, and I hope and expect that President Obama and others will be able to disenthrall themselves from some of the ideas and misconceptions of the past. Lincoln was president when the 13th Amendment was adopted, irrevocably abolishing slavery throughout the country. But I think what's interesting is Lincoln's relationship to the abolitionist movement, which really created, abolitionists weren't really important members of Congress, most of them, et cetera, but they created the public awareness, the consciousness, the public discourse that gave rise to the concept of equality in the Constitution in the 14th Amendment. One abolitionist said that the abolitionist movement was the school of rights. It's the abolitionists who for years, decades, struggled to create the idea of an American citizenry unbounded by the tyranny of race. And despite our admiration for the Founding Fathers, they did not create any such thing. They created a slave-based society in which African Americans enjoyed far, far less rights in all ways, even free blacks, of course, not to mention the slaves, than did white Americans. But it's in the great crisis of the Civil War and Reconstruction that the abolitionist vision of a country based on this notion of equality beyond race, as you know, is written into not only the Constitution but federal law like the Civil Rights Law of 1866 and subsequent laws during the Reconstruction era. I'm not a lawyer, certainly not a judge. I can't tell people how they should think in lawyer terms.
Thank God.
All right. But I think the key thing about these Reconstruction era amendments is that Congress intentionally left the language open-ended. There was debate in Congress about whether to list a whole series of rights which everybody ought to enjoy. And John Bingham and others who wrote those amendments eventually decided, no, that is not what we should do, because we might leave some out by mistake. And also, concepts of rights and equality change over time. So they wrote into the Constitution a set of principles, general, vague principles, equal protection, privileges, immunities, etc., on the assumption that future Congresses and future courts would breathe substantive meaning into those concepts as time went on. Of course, our history didn't work out that way. The courts and the Congresses, etc., began rather quickly to restrict the meaning of those amendments, and we had a long, long period, as you all know, well into the 20th century, where the notion of equality for African Americans was fundamentally abrogated or ignored by the courts and the politicians. But the one point I want to make is that part of that, and only one part, but important, was a misreading of history. You know, the Reconstruction period was for many, many years viewed as sort of the lowest point in American history, corruption, misgovernment, because African Americans were given the right to vote. That was the explanation of those older historians. And this view of Reconstruction was based on a fundamentally racist view of American democracy and of the capacity or incapacity of African Americans and their inability to participate, really, in American democracy. Now, that view has been overturned long ago. Historians today see Reconstruction as a period of tremendous hope and progress. And the tragedy of Reconstruction was not that it was attempted, but that it failed. And this first effort, born of this tremendous crisis, to really give meaning to the idea of equality in America, proved to be abortive and was followed by the long nightmare of Jim Crow, disenfranchisement, etc. And it took another century almost for us to again get to the so-called second Reconstruction of the Civil Rights era. But all right, now I will stop. My final point is that the Supreme Court hasn't yet learned the new history, even up to this present day. If you read their cases which arise out of the decisions out of 14th Amendment or civil rights law jurisprudence, you will find echoes of that old discredited view of Reconstruction, which helps to create a cramped and, I think, highly limited view of what the 13th, 14th, and 15th Amendments were all about. So my parting word is, both to the people here and to the 9 men and women on the Supreme Court, learn the history of where these amendments came from if you want to really apply them in the spirit in which they were written. Thank you.
Thank you, Eric. John Payton, please.
I want to pick up right where Eric was. The historians wrote early histories of Reconstruction, and I would say Reconstruction didn't fail, it was destroyed. And the early histories of Reconstruction, if you read any of them today, and you wouldn't have occasion to do it, but if you do, they are really awful things to read. They are filled with racism. They don't just say that black people shouldn't vote. They say they are incapable of serving as officers in a democracy. They are inferior beings, and we simply have to reorganize our society to deal with them as inferior beings. The most prominent historian said that. One who taught at Columbia and was quite famous in his time was William Dunning. He controlled this field. And he said, as a non-controversial matter, what I just said. The historians have, in essence, gone back and revised all of that. Eric wrote a tremendous book called Reconstruction that tells the true story of Reconstruction. The lawyers and the courts have not done a similar thing. So all of our cases from this really awful period of the destruction of Reconstruction remain as cases that, believe it or not, are still cited. I'm going to just give you one example, and then I'm going to say how Thurgood Marshall looked back on this. And the example is a case that a lot of lawyers have heard, and today many other people have heard too. It is the case about the destruction of Reconstruction. In 1873, on Easter Day, a group of extremely well-armed former members of the Confederacy surrounded the courthouse in Colfax, Louisiana. Colfax is the name of the Speaker of the House, whose name is on the 14th Amendment. And they surrounded it because there had been appointed a black sheriff, the first black sheriff, and inside the courthouse were hundreds of black people defending their first black sheriff. This is a defense of justice and the rule of law. They were well-armed. They attacked, laid siege to the courthouse. They blew it up, set it on fire, and killed hundreds of black people. 3 white people were killed. The result of that was, obviously, you can't get any recourse from the local authorities. They were destroyed. The result of that was, a year or so later, a federal grand jury indicted 100 or so of the participants. That was whittled down to just the ringleaders, and they were tried for violating the Enforcement Act, which says you cannot go together to intimidate. You know the act. And at that trial, they are convicted. Riding circuit was Justice Bradley from the Supreme Court. And he sat in on the trial, riding circuit. And when they were convicted in court, he intervened and said he found the trial unlawful and freed the ringleaders right there in court. That case is then appealed to the Supreme Court. In the Supreme Court, the case is handled by Rafferty Johnson. And Rafferty Johnson's a former Attorney General of the United States, but he is best known in this context as the man who argued for the slaveholders in Dred Scott. Okay, that's who he is. He wins that case, and they are exonerated. This is in every way the end of Reconstruction. That is the overthrow by armed white insurgents of a government in Louisiana. The case is Cruikshank. If you read Cruikshank, you will not be able to figure out a single thing I just said. It contains no history. Okay, you won't figure out a single thing. We have a parade of cases: Cruikshank, Slaughterhouse, the civil rights cases, Plessy, Missouri versus Mississippi versus Williams, Giles versus Alabama, on and on and on and on, that are using a history that is corrupted, okay, and filled with racism. Those cases remain as cases, okay? Believe it or not, some of them are still cited for things that matter today. The historians have gone back and done this, and the lawyers haven't. Thurgood Marshall, on the bicentennial of the Constitution, gave a speech that turns into a law review piece, and it contains this quote: while the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for justice and equality, the 14th Amendment. The 14th Amendment contains the Equal Protection Clause, it contains the Privileges and Immunities Clause, it contains the clause that says that everyone born in the United States is a citizen of the United States. Those were intended to be revolutionary aspects of our government. And when he says the Union survived but the Constitution didn't, the 13th, 14th, and 15th Amendment were intended to do a revolution to how we actually exist as a democracy. The Supreme Court cases that originally interpret those things are part of the overthrow of Reconstruction, okay? And we should shed those cases. So I'd say this opportunity now may be the first clear opportunity we have to look at what those amendments were intended to do, to see how our country ought to be organized, what did privileges and immunities really mean by the people who drafted that, what did equal protection mean, what did that concept of democracy actually mean for where we are. Unfortunately, the first couple of decades afterwards were filled with people who were running away from the promise of the 14th Amendment instead of running towards it. And we now have a chance, I'd say, to run towards the promise of the 13th, 14th, and 15th Amendment. And I think we ought to take maximum opportunity to actually do this right now.
Impressive. You did it exactly in the right amount of time. John, Tristina?
Thank you. Thank you for the invitation to be here. I too want to make a special note of Bill Coleman, a former MALDEF board member, among the many, many things you have contributed to civil rights and equality and justice through our times. And I hope you are as fascinated as I am and impressed by the speakers we've already heard, and because that sets the tone for not only this coming week, but for the next 4 years and beyond, the next 8 years rather, and beyond. We have the fact that we are sitting here talking about cases from 130, 140, 150 years ago. In 100 years from now, 150 years from now, because I've known and worked with many of you over the past years, I know that people in the next century will be talking about the work that we do together, we've done over the past few years, and we'll be doing together over the next decade. The critical importance of restoring the Constitution and protecting people's rights. And in the same way that the road from Lincoln to Obama, with the Gettysburg Address of making sure that the government is of the people, by the people, and for the people, it stresses people rather than citizens, which is the framework that is of greatest importance to the Mexican-American Legal Defense and Educational Fund. We are still fighting. We are still fighting to be considered people in the United States. That's interesting. You go back and look at the Civil War amendments and look through some of the legislative history. And Senator Howard of California always comes into play in his comments about it was not intended to prohibit the states from excluding. In that era, it was mainly the Chinese immigrants who were the subject and targets of xenophobia and hatred. Today, of course, it is more Latino immigrants. And it is instructive as you look through the history of some of the cases, the major cases that came out in the 1880s and 1890s, were cases of immigrants. Yik Guo versus Hopkins, a Chinese-American store owner in San Francisco. The laundryman cases, where the Chinese launderers were treated differently than white launderers in California, and statutes that had no mention of Chinese or whites. The case of Wong Kim Ark versus the United States. Wong Kim Ark was, like me, he was born in San Francisco a little bit earlier than I was born in San Francisco. He was born in 1871. He took a trip out of the country, came back in 1893, came into the port of San Francisco, and they said, well, you can't come in. Didn't you hear about the Chinese Exclusion Act? And he said, well, I'm not coming in. I'm coming home. I left my heart in San Francisco. I'm born here. I'm a U.S. citizen. They said, no, you're not. He had to go all the way to the U.S. Supreme Court. The Supreme Court made clear in the Wong Kim Ark case what was true, what had been true since 1608 in Scottish common law, in the Rule in Calvin's case, that if you're born in the country, the birthright citizenship doctrine, if you're born in the country, you're a citizen of that country. Now, the 14th Amendment included born or naturalized, which becomes relevant to us today. But prior to that time, you could be born in the United States. We got stuck on that doctrine when it came to treating people as 3/5 of a person for census purposes, and the later cases with Indians. And we thought that had been resolved in 1898 with Wong Kim Ark. But still today we have people like Lamar Smith, a ranking member of the House Judiciary Committee, who feels that birthright citizenship shouldn't be applied to the children of undocumented immigrants, and on and on. So today we still have the fight, the unfinished fight, to make sure that all people are considered people, all Latino immigrants particularly, are considered persons. Just this morning I was at a press conference for the S-chip bill for children's health. Legal immigrants are excluded for the first 5 years as children from coverage under that bill. So we have many, many small and big things left to be addressed. But certainly, I am pleased to be with this panel to be able to discuss these issues today and continue our work together in the next 8 years and beyond.
All right. Thank you, John. Doug Kendall.
Thank you. And just say first that I am just delighted and honored to be on such a remarkably distinguished panel and before such a distinguished audience. Constitutional Accountability Center is a think tank, law firm, and action center dedicated to the progressive promise of the Constitution's text and history. We were formed in June of 2008 to try to shake up the debate about originalism and the Constitution in this country. Our point is simple. The Constitution's text and history matter intensely, and they favor progressive, not conservative, outcomes across a broad range of constitutional debates. At the center of our effort are the amendments that have been passed by we the people over the last 220 years. Conservatives tend to view these amendments as tinkering around the constitutional edges. As John mentioned, I think most progressives view these as profoundly changing the document in fundamental ways that the Supreme Court has often not recognized. At the center of this debate over the amendments are the Civil War amendments, in particular the text and history of the 14th Amendment. That's why we're delighted to be co-hosting this event. As my predecessors have indicated, across a range of issues, the Court has gotten this history wrong. We have recently released a report called The Gem of the Constitution, the Text and History of the Privileges or Immunities Clause, which is in your package and everyone should have. And I wanted to recognize David Gans, who's in the audience today, who's on CAC staff, who's a principal author of the report. This is the first of what will be a long series of text and history narratives that form the foundation under all the other work that Constitutional Accountability Center is doing. And we started with the Privileges or Immunities Clause because there is no area of the Constitution where the text and history depart as radically from Supreme Court rulings as with the protection of fundamental rights and liberties under the Constitution. There has emerged in the last 30 years or so a remarkable scholarly consensus about the intended prominent place that the Privileges or Immunities was to play in the 14th Amendment and in the protection of fundamental rights and liberties under our Constitution. Similarly, there is now almost universal agreement that the Supreme Court got this fundamentally wrong in what John mentioned was the slaughterhouse cases. As Akhil Amar, an historian from Yale, a constitutional historian from Yale, has said, virtually no modern scholar, left, right, or center, believes that the slaughterhouse case is a plausible interpretation of the 14th Amendment. And with the Privileges or Immunities written out of the Constitution, the Court has turned to the Due Process Clause of the 14th Amendment for applying and protecting substantive rights and liberties against state action. The result is a doctrine known as substantive due process. For a bunch of reasons that I won't rehearse here, substantive due process is less than a perfect actor for the constitutional role it is playing. And the result has been the constitutional equivalent of a food fight, with liberals and conservatives fighting about the validity of even the protection of fundamental rights under our Constitution. Conservatives use substantive due process as Exhibit A of their case that liberals want judges who make up the Constitution as they go along. Liberals point to the attack on substantive due process as Exhibit A in the case that conservatives want to roll back fundamental protections, even for the rights protected by the Bill of Rights. And it should make everyone who cares about text and history want to scream, because this entire debate goes on without any recognition of the text and history that matters, the text and history of the Privileges or Immunities Clause. And so the two questions that arise from that, two profoundly important questions, are one, can we do anything about that conversation? And two, what would happen if we did? And we'll save most of this discussion if we want to have it for questions and answers. But let me just address both those points quickly. There are two reasons, I think, despite the Privileges or Immunities Clause being written out of the Constitution 140 years ago, that this conversation could change. The first is a 1999 case called Saints versus Roe, where the Supreme Court struck down a California welfare reform act as being violative of the Privileges or Immunities Clause. It was the first time the modern court has treated the clause as anything but a dead letter. And the 7-2 ruling, written by John Paul Stevens, joined by Justice Kennedy and Justice Scalia, shows at least a modicum of support across the ideological spectrum on the court for reconsidering the meaning of the clause. The second reason, I think, for some optimism is the Supreme Court's 2008 ruling in Heller, which recognized, which sets up what I think is a critically important next case about whether and how the Constitution protects the Second Amendment's individual rights against state action. There is only one textually and historically faithful way to incorporate the Second Amendment against the states, and that is the Privileges or Immunities Clause. So a big test is coming for the Supreme Court, and there is at least a possibility that in the next decade or so we will actually have a Privileges or Immunities Clause. So why would that matter? Well, let me just read a passage from Barack Obama's book, The Audacity of Hope, and I'm cutting it down a little bit. For all our disagreements, we would be hard-pressed to find a conservative or liberal in America today who doesn't subscribe to a basic set of individual liberties identified by our founders and enshrined in our Constitution and common law. The right to speak our minds, the right to worship how and if we wish, the right to peacefully assemble and to petition our government, the right to buy, own, and sell property, the right to be free from unreasonable search and seizures, and the right to make our own determinations with minimal restrictions regarding family life and the way we raise our children. We consider these rights to be universal, a codification of liberty's meaning. I think Obama is right. I think we Americans do believe in a basic set of equal and inalienable rights. This is little more than a restatement of the central passage of the Declaration of Independence, a passage that states the idea of America and establishes our national creed. The problem is that the specific provision that was intended to write the idea of liberty from the Declaration into the Constitution has been written out of our founding document. All Americans should cheer and push for a ruling that brings back this critical text in history. We will continue to disagree about what constitutes privileges or immunities. But if we do this, we may find that Obama's right and that we agree more than we think about our basic and inalienable constitutional rights.
Thank you, Doug. Before I ask a more general question, I guess I have to ask you a question for clarification. Are you suggesting that the distinction between United States and state citizenship in the way that the P&I clause is interpreted will disappear, or are you just suggesting that there will be more things acknowledged as privileges and immunities, or will they all be lumped together as privileges and immunities without regard to whether they are of citizens of the United States or of the states?
I mean, obviously, the specific intent of the 14th Amendment was to apply the protections of the Bill of Rights already recognized against federal action to the two states, and because the Supreme Court had ruled in 1833 that the Bill of Rights didn't apply against the states, and so
Barron versus Baltimore.
Yeah,
but
Barron
that's not what I'm
Baltimore.
asking you.
No, but so I think once we have what are called privileges or immunities of United States citizens, I think it's impossible to say that those privileges don't apply against both
Okay, so you're just saying
state and
expand
federal
them.
action.
Okay, clear. Now, on the question of history that Eric and John talked about at great length, and the others of you, I guess, agreed, why should a judge be persuaded to believe the history that Eric Foner has written any more than the history that William Dunning or Herman Belts or some other people I can name have written about the 14th Amendment? And do we not, as historians, create problems ourselves when we adopt the posture that each generation writes its own history? We believe in revisionism. So what is to say that the judge ought to believe your history?
The only, as Oscar Wilde said, the only obligation we have to history is to rewrite it. And I don't, first of all, in all modesty, I should say I'm not the only one who has written, it's not just my history, but it's an entire generation of historians. This is not, what we write now is not the final word. There, as Mary's suggesting, there never is a final word in the study of history. But I do think that that judges at least ought to be obligated to be aware of what the most up-to-date, most widely accepted scholarship is on these key issues. Yes, 50 years from now, probably there'll be changes in what historians say about Reconstruction. But what I'm really saying is that too many instances seem to exist of judges being trapped in an older view of Reconstruction, which, as John said, arose out of an entirely different society. And the old view of Reconstruction was really, in part, a foundation for the Jim Crow system. The lesson of it was African Americans are incapable of exercising the right to vote. Therefore, the white South was justified in taking away the right to vote, as it did around the turn of the last century, with many other discriminatory, prejudicial implications in it. So to remain wedded to that view is to remain wedded to the assumptions of a society which I hope we have moved considerably beyond into the 21st century.
Could I just say something?
Yes, of course.
I think, if you start with your question, that question then must assume that we have to know something about the history. We can argue about which history is correct, but if we have to know something about the history, then we have to look back and make some judgments. One of the things that is most shocking about William Dunning's history, he wrote an essay that ran in the Atlantic Monthly. It's in his collected works, and it's called The Undoing of Reconstruction. And that essay is remarkable because it doesn't pretend that, in fact, that history he wrote was correct. It says, they tricked them here, and they tricked them there, and they tricked them there, and at the end, we actually undid something that had been set in place by the 13th, 14th, and 15th Amendments. Okay? We had to do it that way because we all realized black people were inferior. We just had to do it that way. If you care about the history, then the history that's important here isn't William Dunning's history. It's the history that animates the people who wrote the 14th Amendment. That if you really want to know what did the 14th Amendment do, you don't read someone in 1904 who's writing about the end of Reconstruction. You read the actual report of the Joint Committee that drafted the 14th Amendment. And I don't think you're going to find any of those Supreme Court cases that refers to any legislative history of the 14th Amendment. None at all. okay? Because if you go down that road, you have to come out another way. So if you say history matters, and I think your question presumes it does, then here's where you go to find out what the 14th Amendment actually was intended to do. You go to the people who actually wrote it. There is an actual legislative history of the 14th Amendment. It's a report. I have it. I have the report of the Joint Committee. And here's what their hearings concluded. You can now find the journal. You can find all sorts of debates in Congress about what he was supposed to do. Instead, what we have in these cases in the 19th century is just remarkable statements. Everyone knew that we didn't want to do this. Everyone knew this is what these amendments meant. That's actually written into it. It just says it that way. So I take the question. If the history matters, then what's the history that matters? It is, what's the legislative history of the 13th, 14th, and 15th Amendments? What were they intended to do? And then the history that Eric wrote about and then William Dunning's writing about is sort of how people, for political purposes, tried to actually walk away from the promise of those amendments. Okay? That's how that ought to set up. Okay? We don't have any Supreme Court case that delves into this the way I just said we ought to delve into it. Because if you go there, you will see just what was intended out of this. It was a breathtaking, Thurgood Marshall's statement is absolutely right. While the Union survived the Civil War, the Constitution did not. If you start there, you've got to figure out what those three amendments were intended to do when they changed the Constitution.
Yes, Joe.
I agree with everything that John just said. The one thing I'd add to that, though, is that while there is still a remarkable dearth of good information available about the founding of the Civil War amendments. While we have lovingly presented and restored all the history about our framing era, there is still basic information that is not all that easily available about the framing of the civil rights. For example, the debates of the states on the passage of the 14th Amendment. If they exist, they have not been found in most cases. There are the speeches we just put up on our website, the major speeches in support of the 14th Amendment. They're available on the web in a lot of sites. As far as we could tell, there's no other available site where you can they are fully searchable, so you can look for specific words and things like that. So there's a ton of additional historical work and making that history available that still needs to be done. And that's, I think, one of the things that if the Obama administration wanted to make this a priority could lead, that their Justice Department, their Department of Humanities, there's a ton of just scholarly work that could be seeded and that could be done during the course of where the calendar favors this effort. We're about to celebrate the 200th anniversary of Lincoln's birth. There's going to be a series of 150th anniversaries of the start of the Civil War, of the battles, of the passage of these amendments. All these will give a terrific opportunity for somebody to get on their bully pulpit and talk about these issues and bring some of this history back.
Mm-hmm. John, do you have any views on all of this?
No,
the uses of history, the uses of history for your.
But in our work in immigration, it is the anti-immigrant and the language issues in particular come up in a historical pattern also. And I think back to Meyer versus Nebraska, 1920s, anti-German sentiment. At that time, it was German immigrants. As I said earlier, in the 1870s and 80s, there was the anti-Chinese movement. But Meyer versus Nebraska, the protection of the Constitution extends to all, to those who speak other languages as well as to those born with English on the tongue. And perhaps it would be highly advantageous if everybody spoke the English language. But you don't reach those positive policy points by abridging people's constitutional rights. So that is the same argument we make today in front of, whether it was in front of S.I. Hayakawa a few years ago or in front of others, is that these are very, while they are points of history, they certainly recur, and we're now in another resurgence, another opportunity to move forward.
Yeah. I only have one other question generally before we, you can ask each other questions if you'd like. but Plessy against Ferguson, Harlan's opinion in it. Isn't Harlan's opinion something of a barrier for the kind of interpretation and
You mean
kind
because
of
he said the Constitution
persuasive
is colorblind?
arguments that you wish to make to judges about where the law should go today? Hasn't his opinion, you know, when Harlan died at his funeral, all the black folks came, and he was the great savior. And then, as you know, in the 80s, in the way the cases were argued and the way the right evolved its views on the Constitution, they were always, you know, quoting Harlan to us. And after they said Martin Luther King was colorblind, that Harlan was, and so why were we trying to get all these remedies? So when you start talking about reinterpreting the 14th Amendment and remedies, what do you do with Harlan?
You know, I think Harlan's, this phrase, the Constitution is colorblind, which is what you're referring to, right, and which was picked up a century later as a sort of conservative mantra to oppose any recognition of race anywhere, is really wrenched out of context of that dissent. Harlan was the one dissenter in Plessy v. Ferguson, and you know, that dissent is an argument about slavery and freedom in America. It's about how state-imposed segregation is a violation of the emancipation of the slaves. It's holding people in a kind of subordinate status which is akin to slavery, and that the promise of the Reconstruction Amendments was this equality of all before the law. That's what he means by the Constitution is colorblind, that the states can't discriminate against one group of people or single them out as unworthy to associate with others. So, you know, I think if you read that whole dissent, it's actually a very ringing statement about a broad understanding of what the abolition of, you know, he was almost saying that this was a violation of the 13th Amendment, not so much the 14th Amendment, that if you relegate black people to a subordinate status, you're putting them back into a system akin to slavery, and that's not what the abolition of slavery really was intended to do. So, you know, I'll stick with Harlan, and I think he's been much misused by more contemporary, politicians.
I think it's very hard to understand any phrase like that out of context. So I completely agree. Our Constitution is colorblind. It recognizes no superior race. That's the next line. He's not talking about remedies. He's not talking about the Freedmen's Bureau. He's not talking about the enforcement acts or any of those things out there that, in fact, were despised by folks out there because they said they were favoring the freedmen or black people. He's talking about our Constitution is colorblind. It doesn't recognize a superior race. And, you know, Harlan is a very interesting figure in our history because he didn't just become a Supreme Court justice out of nowhere. He actually litigated in the Justice Department these civil rights acts we're talking about on the front line. That gives him really special, I'd say, stature for the appreciation for how all of this works. The reason the country turns on Reconstruction is racist. And the way they have to turn is to say that it can't be that black people have rights out of the federal government that trump what the states can do, because if they do, then in fact the federal government has responsibilities and the states can't manage black people like the Redeemers want it to happen. The case I discussed, Crookshank and that massacre, if in fact there are rights that have to be observed that all of the people that were massacred had, then in fact the Enforcement Act would have come into play. And what the court has to say is, for all sorts of reasons, you know, there are rights and then there are states' rights, and, you know, the states' rights are up to the states. And none of these things are actually about the states' rights. The context was, this was a group of armed insurgents that destroyed the state's courthouse. They destroyed it. Okay, if there are any rights left, it's the rights out of being a federal government and all of that. All of these cases have to make a distinction. They say, actually, there's almost nothing that you have that are rights that don't come from the states, and what comes from the federal government is very, very small. It's actually about access to ports. That's actually what Slaughterhouse is. It's about access to ports. Okay? If they come out another way, you can't end Reconstruction. You can't do it. Okay? When we are past Reconstruction, and most of the people in the country would agree with the list of things that Doug read off, gee, we have the following rights, the only reason you have any of those rights is there's a 14th Amendment. You can't find them in the Constitution as drafted. At all. You just can't find them. You can see that, gee, the federal government can't do these things, but that's not the question, is can any government do these things? And the only way we have those things we now see as national rights is that the 14th Amendment, and the phrasing that all the lawyers now use is incorporated those rights. And the question that Doug raises is, was that a cramped way of getting there, through the due process clause or substantive due process? Wasn't it drafted with a much more open door, which is privileges and immunities? And if you read the history, it was supposed to come in as privileges and immunities of being a citizen of the United States. Okay? The reason we are stuck in this funny hole is what was required if you want to destroy Reconstruction. Okay? We're way past that. We're way past that. The historians have actually figured it out. They write the right history now. We're stuck with these ridiculous cases where we have a parade of cases that say things that when you read them and you then read the context, you want to start laughing. But there's still precedents. There's still precedents. When the former Confederate states were seeking to be readmitted to the Union. So let me give you one. Mississippi wants to get back into the Union. In 1868, it comes before Congress, and it says, we have a Constitution that guarantees that we will not discriminate on the basis of race in voting. And Congress then passes a resolution readmitting Mississippi with the following, and this is the term in the congressional resolution, the following fundamental condition, that you will never change to impair the right to vote that is in the Constitution that you have presented to us today. You will never impair that right to vote. In 1890, after Reconstruction is destroyed, Mississippi adopts a constitution that they flagrantly said was designed to keep every black person from voting. Okay? What came of that? Okay? That's Williams versus Mississippi. The Supreme Court says, I don't see a problem. You see a problem? Okay? As soon as Mississippi does it, this is called the Mississippi model, Alabama does it. That's Giles versus Alabama in a despicable opinion by Oliver Wendell Holmes. It says, black people seem to have a problem with the white people. If the black people have a problem with the white people, you better go talk to the white people. We can't help you. Okay? You got to think this through. This is still precedent. Giles versus Alabama is still precedent. It says you can't get an injunction if the majority just doesn't like you. 13th, 14th, and 15th Amendments, if they are designed to do something that no one doubts, it is to actually keep the majority from doing things exactly like what I just described. Okay? We got a parade of cases. Okay? That's the history that plays in there. And all I'm saying is that we now have to sort of start the process that actually cuts those loose and lets them just be historical relics. Okay? And to the extent some of our doctrine has been tied to those, we ought to untangle it. Okay? And you can only do that by now looking, maybe for the first time, what were these amendments really designed to do? Don't start by saying, well, what did happen in the civil rights cases? That's still good law, isn't it? Okay? That's not the way to do this.
So you do the history with the good history, and you cite the cases, and you make the arguments, and you hope, like Doug said, that you see some glimmers that change is coming in a couple of the opinions that have been written recently. And then you get some new judges appointed by Obama and confirmed by the Senate.
I think you got to start there, Mary.
And then you will have them influence the others.
Yes.
and then you can turn this whole thing around. Okay.
Yes.
All right. Now, before I open the floor for questions, does anyone want to comment about anything else that anybody else said? All right. So the floor is now open for comments or questions from the audience.
Someone way in the back.
Yes, that's Phyllis, I think. Hi, Phyllis.
I'm Mary Frances.
You're in my book.
Oh, good. I'll look for myself in the index. I was shocked to learn that there was an effort to repeal the 15th Amendment in the latter part of the 19th century, including by none other than Robert Todd Lincoln. Whatever happened to that effort?
I have no idea.
Neither did I. You've got us.
You got us, Phyllis. Do you know what happened?
Well, it obviously didn't succeed, I think. But
How did they subdue it?
I did not know that.
Well, I know I can do 90 seconds on this. Robert Todd Lincoln, I'd say, is a strange, disappointing, and tragic historical figure. He becomes, the head of the Pullman Company. And the Pullman Company, if you didn't know the full history, runs sleeping cars, and they are a gigantically successful business, and every railroad company has to have Pullman sleeping cars. And the selling point of the Pullman sleeping car was that it employed former slaves, not black people, former slaves. And the ads are, you can live the dream. Ask and they will do. Okay? And there is a special census category for Pullman porters. Okay? And those are, right. And he becomes the head of the Pullman Company. Oh, and by the way, obviously there is no upward mobility out of that job classification. Okay? All of the people that supervise the porters have to be white. Okay? And the tragedy of Robert Todd Lincoln is he decided that would be a great job. I'm the head of the Pullman Company. My daddy freed him. And now I'm going to employ him as former slaves working in jobs where the job requirement is you have to be a former slave. So I'm not surprised. It's just part of the, I'd say, profound disappointment of sort of that tragic figure.
And the Pullman Porters, of course, later were organized, and A. Philip Randolph,
yeah.
and became the first black-led union in the AFL-CIO.
Yep.
Right?
Yep.
Okay. Anybody else have a question or comment? I can't see whether.
I just have a quick question about the Privileges and Immunities Clause pertaining only to citizens, whereas the Substantive Due Process Clause pertains to persons. And is there any tension in that? And would you like to expound on the legislative history? Why is one for persons, including immigrants, and why is one only for citizens?
Yeah, sure. It's one of the hardest and best questions about what happens if you do this, if you go to privileges or immunities rather than substantive due process. There's probably 3 or 4 answers that I'd kind of sketch out. One is that, first of all, the concept of citizenship is broader than it's been recognized today, meaning, as John said, we should be, that citizenship under the 14th Amendment it broadly includes citizens, the children of undocumented aliens, and gives broad naturalization authority. The second answer is that, as I read the text and history of the 14th Amendment, that the founders particularly, guaranteed both due process and equal protection to everyone, broadly establishing persons, and then established privileges or immunities clause for citizens, which it's unclear exactly. If you have due process, which includes all the jury trial rights, all the habeas rights, all the things that are about providing a fair criminal procedure, a fair, and prevent procedural rights from being taken away. And then you have an equal protection clause where the Supreme Court has interpreted it to give strict scrutiny against distinctions based on alienage. It's not clear. That seems to get most of privileges or immunities to aliens. In some parts, perhaps, like some substantive protections, perhaps like the right to bear arms, perhaps there should be, perhaps we do want a little more federal authority to limit the right to bear arms of documented and undocumented aliens in this country, and maybe that protection applies slightly differently in that context. And then the final point I'd make is that there's the citizenship point cuts both ways. There's a lot of anxiety among progressives about aliens not being included as citizens under the Privileges and Immunities Clause. There's a lot of anxiety also by conservatives that corporations aren't citizens within the Privileges or Immunities Clause. And so it kind of cuts both ways. It's a very difficult question. It's hard to see how the Supreme Court will sort it out if it goes this route. But I think that that dynamic is going to end up where there's most protections and every protection that we care about that goes to citizens will also be extended in some form or another to everyone in this country.
John,
I would
wait
say-
just a minute, Chester.
Yeah, I would just add that the line between citizens and non-citizens has, as Doug said, been blurred greatly over the years. Non-citizens have the right to pay taxes, and also serve in the armed forces. And also, while we typically consider the line to be drawn at voting, well, we have plenty of citizens right here in the District of Columbia who have no right to vote for a United States Senator or no right to vote for a member of the House of Representatives who has full voting rights. Same thing as the U.S. citizens in Puerto Rico. So you have a line back and forth between citizens and non-citizens, but typically it has been blurred.
Go ahead, because my understanding of the history of it is, and I once wrote something about this years ago, that at the time, I'm not talking about now, there was a clear distinction in the minds of the framers between the notion that you want all persons, whatever their status is legally, to have certain protections, but that citizenship was in a different category, that if you were actually a citizen of the country, you had more responsibilities to the country. And as John points out, now if you're not a citizen, you serve in the military, you do a lot of things. But at the time, there was this clear idea of what citizenship, being a citizen, meant, and that you had more responsibilities to the nation and more, therefore, more rights, whatever they were, and that they understood those categories at the time.
Yeah, look, here we have some, real historical debates back and forth. One of the parts of the debate over the 14th Amendment is a Southern member asks a question, I believe, of Bingham, and it is, are you saying that black people would be allowed to operate as citizens, officers of our democracy, serve on juries? Are you saying serve on juries? Would you let them serve on juries? Officers, that's an officer of our government. Are you saying they could be, that's what a citizen is, are you? And the answer was yes. But that is going to your point that that was a very different elevated view of what it was to be a citizen. And it was not about rights, it was about responsibilities. You had a responsibility as a citizen, as an officer, sort of the government. Most of the criminal power comes through people who sit on juries.
And you had a responsibility to serve in the military. Remember in Dred Scott,
That's right.
where Taney says that how do you know that blacks are not
Because they can't be in the
citizens
military.
and were not at the time of the founding? It's because they could not belong. They had no responsibility to be part of the service. So, and we're not talking about whether somebody wants to be part of now. We're saying that at the time, what they understood. So they saw a clear distinction between the category of citizenship.
The thing is that I think, and here I'm speaking as a historian, we should not be locked into the history, actually, of that. In other words, we need to study the history to know what the general principles that the people who put these key amendments in the Constitution were trying to implement. But it's not our job to kind of recapitulate their thinking 150 years later. I mean, for example, non-citizens could vote all around the United States at this time. There was aliens could vote in New York City. Many of them were, immigrants could vote right away. Tammany Hall, etc., brought them in to vote. So and on the other hand, citizenship was not thought, for example, to necessarily carry with it the right to vote. Women were citizens, but nobody at that point, except for a few women feminists, thought they should have the right to vote.
Some had voted.
Some had voted, but it was not considered automatic that if you were a citizen, you therefore could vote. The whole issue of citizenship at that time was shaped by the Dred Scott decision, which had denied the ability of any black person to be a citizen. And in a sense, the Civil Rights Law of 1866 and the 14th Amendment are efforts to overturn and eradicate the Dred Scott decision, which was universally, at least in the North, considered the most infamous of all the decisions of the Supreme Court at that time. We're not fighting the battle of the Dred Scott decision in the year 2009. In other words, we can't. So, and you know, there are issues today which you can't find in the record. I mean, Lawrence v. Texas, you know, where 14th Amendment rights are extended to homosexuals. That was not an issue in the Congress of 1866. That doesn't mean that the court was wrong in that. It's that they're actually living up to the intention of the framers of the 14th Amendment, which was, as I said, to create a kind of a living, open-ended concept of democracy and equality, knowing that it would expand and change over time. So even though I believe we must know that history, it shouldn't just become a burden where we say, well, what would Bingham have thought of this? Or what would Thaddeus Stevens have thought of this? We got to think about it ourselves, but within a framework that was created back then.
So that's why I'm saying that what it does is it opens up quite radically what our democracy is and what its aspirations are and how those can come together. And, you know, when Eric says, gee, they used very general language with very general concepts, they did. You know, it could have been a very, very specific set of amendments that had, you know, details. Instead, it's very lofty.
Which was what the Civil Rights Law was.
Right.
The 1866 Civil Rights Law is a list of the rights you can have.
Right.
But they didn't want to put that in the Constitution because they said, no, that's not what a Constitution is. A Constitution is general principles, not every single right someone ought to enjoy.
Equal protection of the laws is a very broad concept.
Right.
Privileges and immunities, very broad concept because it doesn't list them. Doesn't list them.
But it also depends on whether you're trying to persuade somebody or not and whether they agree with you. I mean, I agree that it's a living Constitution, but there's some people who don't. And also Doug's point about trying to show that even if you believed in originalism, which is one of the things he tries to do, if I understood it correctly, that you can tell from the historical record that there's enough support for the kinds of interpretations that originalists would have to accept if they are originalists and they don't believe in the living Constitution. There's this other thing, though, that you have to come to grips with, I would think, is the history that was on everybody's mind, as Eric said, at the time, was Dred Scott. And if Dred Scott was on their minds, I mean, when Bradley says in Slaughterhouse that the history is so recent that we all know it, remember that part?
Yes.
So
that's why he didn't
he's
have to go
saying,
into
wait a
it.
minute, he's saying, right, he says, I don't have to go into it because the history is so recent that we all, whatever, know it. He must have been talking about the history of the Civil War and the whole Reconstruction and Dred Scott, okay? But his view of it was different from the view that we are taking.
As the dissenters pointed out.
Right,
They said,
and so they all had
the
different
history you're
views,
putting out
even
is
though it was
absurd,
so
yeah.
recent that they all, well, anyway, I don't know where that leaves us.
Look, Mary, we're now talking about the exact same time when we have members of the Supreme Court that are asked to and then do decide the next election.
Yes.
And I'm not talking about 2000.
1876.
1876.
Bradley is the guy who decided.
Bradley is the guy.
1876.
And that decision was about, are we going to, as a matter of finality, right, actually do something that we know withdraws every troop from the South and completely ends Reconstruction. They're in an incredibly political moment for those several years, and you just have to see what they do in that political context. And Bradley is the prime player.
And he's also the civil rights cases guy.
He is.
Yes.
Absolutely.
And some other things we could name. Yes.
Yes, you mentioned that it was unclear that the word citizens, citizens apply to corporations. What about the word person in the 14th Amendment? Is there any evidence whatsoever that the intent of the framers was to include corporations in the word person?
There's a funny story. There's a funny story about, oh, you go ahead.
No, go ahead. I don't know your story, but I'd like to hear a funny story.
About arguing before the Supreme Court. And in the oral argument, it was a railroad lawyer, I forget who was.
Conkling.
Yes.
It was Roscoe Conkling.
And then the judge says, we assume, that persons include corporations. And so they just did it just like that. There's nothing in the record of the 14th Amendment that we know about.
Conkling, this is a good lawyer's trick.
And I was there, he says. I was in the
Conkling
Senate.
held up what you have, the Journal of the Joint Committee, and he said, anyone who looks at this can see that they intended corporations. There wasn't a word in it about corporations. But it was, it was a nice trick.
They didn't look.
They didn't look. But if you believe in original intent, if you really believe in original intent, you should forget about the idea of corporations being persons under the 14th Amendment, because there was no evidence at all in 1866.
I think it was Santa Clara Railroad.
See, it was Santa Clara. Nobody then was thinking about corporations, believe me.
The only reason the distinction matters is because Supreme Court case law says or holds that it's still good law today that corporations are persons and are not citizens. So I'm not saying that that line is defensible, but that's where the Supreme Court has drawn the line.
Okay. Yes. And then I'll get to you in the back, just right here.
Certainly since Thurgood Marshall was behind the Brown versus Board of Education, and he was always a person that you certainly wouldn't describe as shy, there have been civil rights lawyers in the 50s, 60s, and 70s who were very much attacking those same civil rights cases and looking at the debates and the records, which is what lawyers often look at and ignore historians. So I guess my question is, where has this argument been? Was it made and rejected? Was it never made? Is it in dissents or briefs? How did it escape people for the last 50 years to not push this argument?
Let me try. I think it's, again, you sort of have to go back. So let's go back to Brown. So Thurgood Marshall is arguing in Brown. And the context of Brown is that when Brown is argued, there is no federal civil rights law that is being enforced. There is no anti-discrimination principle that is sort of catches everyone's imagination. We're a country that by law is segregated by race. We have entire job categories where only white people can be in them. And we have entire job categories where black people are supposed to be in them. So we're in a completely different world. We're in a world of white supremacy. Brown is argued in the context of white supremacy. Okay? Nothing that Brown decides changed a single thing I just said. Okay? So this is a very strange place. Thurgood Marshall does say in his final argument in the Supreme Court, he says, we have always said that the laws at issue in this case cannot be distinguished from the black codes. And the black codes are what the 14th Amendment was designed to knock out. And that's right. This discussion we've had, the black codes are what was to be knocked out, which is a whole panoply of laws that reorder everything. Okay? Some of them were race neutral. Okay? Anyone who walks off their tenant farmer job can be arrested and sent to prison. You don't have to say race. They're all black. Okay? So Thurgood says, we have always said you cannot distinguish this from the black codes. And if that's right, the only way we can lose is if you say that black people are inferior for some reason to white people. We say this Constitution does not condone that. Those are the last words he says. Okay? The court can't go there because their decision is inside of white supremacy. Just think about this. So they say, actually, we find the scheme you have to be violative of the Constitution, and we say segregated schools on the basis of race are by definition violate the Constitution. But they don't have the power to say white supremacy is just gone. Okay? In fact, that argument is made but the court simply won't pick it up. Okay? For whatever reason, the court is in a very funny spot. It was unclear what was going to happen when they decide Brown. It is a wildly unpopular opinion. And if you don't know, no one came out in favor of it. It was wildly unpopular. The President of the United States, Dwight Eisenhower, said he disagreed with it. Okay? This is a very perilous moment. It's not that Thurgood wasn't making that argument. He made exactly that argument. That argument is in the briefs. It's in the oral argument. It doesn't catch because until you make the adjustment we're talking about, okay, you've got to make a complete adjustment here to say, let's really shed everything and think through what the 14th Amendment is. And that discussion we can have now because the vestiges of white supremacy, no one's arguing for those.
Let me just add one point here about how do we know. This is where I think lawyers and historians take a slightly different approach. I mean, we've been hearing a lot about, quite rightly, going back to the debates in Congress, reading what the legislators, the drafters of the 14th Amendment were saying. That's all fine. But I think historians also look at other people. It's not just the framers. Because, the people in Congress were all white and all male at that time. How do you get the voice of the former slaves into this? Because they were part of the debate at that moment. What about women? They had a lot of ideas. Elizabeth Cady Stanton had a pretty strong idea what she thought the 14th Amendment was about, Susan B. Anthony, but they're not voicing that in Congress. So what we've got to do is expand the terrain that we're looking at. We've got to look at these black conventions. We've got to look at newspapers. We've got to look at petitions. We've got to look at all the things that historians look at to try to create the entire sort of atmosphere of the time, the ideology of the time.
I agree, Eric, but let me say
and this is not to criticize. I'm sure I can't go into court and say, hey, wait a minute, here's what Elizabeth Cady Stanton said, so that's what the 14th Amendment's all about. But you need to understand it within the context of a moment in time that had a far wider, a far larger cast of characters acting than just...
Every moment in time does.
And that's why we have to look at all of those people.
The Joint Committee did, in fact, take testimony from a very broad group of folks all around the country, including the categories you just went over. And that's one of the reasons it's such a rich thing. It is the legislative history, and the legislative history is sort of the transcript of all of those interrogations they made of former slaves, of civic organizations, and they went all over the place and compiled the record. And no one paid any attention to it when those cases are litigated.
Yes.
So, as I understand a point that was made earlier in the discussion, it was that there are progressive principles that were understood when the amendment was being drafted, and historians have figured that out, but judges haven't. And it seems to me that at least in the immediate term, the problem isn't as much that judges haven't figured it out, it's that justices haven't figured it out. And what I mean by that is it's very likely that within a year, we're going to have a very different Fourth Circuit than we have right now. And it's all the more likely that by the time we're looking at the inauguration in 2012, we're going to have a very different Second Circuit, maybe a different Third Circuit, maybe even a different D.C. Circuit. So we're going to have leverage points that we can use to advance progressive principles in the courts, but we will not have the highest court in the land, and the highest court in the land will always have a power to overturn these circuit splits that the Fourth Circuit we hope will create and the Second Circuit we hope will create and so on and so forth. My question is, how can we use judges who are not justices to bring about the sort of revolutionary change in how we view the 14th Amendment that y'all are describing?
Well, one thing they can do is, and I'll let any of you answer it who wants to, it seems to me, as lawyer and historian, that what they can do, people who brief and argue these cases can include the kinds of things that you're talking about up here and present them and make them part of the record so that judges who wish to decide that way can, and just keep, that's the way you do everything. You just keep pounding away at it. You got to make the record. And so I would assume that that's what you would do, and that in the kind of work you're doing, that that's what you're trying. Am I right about that?
That's what you would do?
Yeah. Well, you got to do what the abolitionists did. They tried to create, before the Civil War, an anti-slavery jurisprudence. You couldn't really do it in that society, and certainly the Supreme Court was not receptive to it, but they created a body of thought which, when times changed, was available to people in the Civil War and Reconstruction to go back to and think in a completely different way about these issues of equality and citizenship. So people have to get those ideas out there, even if they may at the moment be rejected at the very top.
And that's in fact what happened in Brown, in the case before that, Menendez versus Westminster, out in California, where there were the Spanish schools and the white schools. And Thurgood Marshall assisted the Latino parents in that case and went up in California courts. And then immediately after the decision, Governor Earl Warren worked with the legislature to abolish those state statutes in California. He shows up in the Supreme Court a couple of years later.
And keep in mind, too, that when I said earlier that there may be some justices, even though not a majority, before 2012, okay? And it is historically acknowledged in the research that's been done on the courts, justices influence each other. Mm-hmm. And if you get some new people on the court, depending on who they are, and if you can get these things pounded away at down in the lower court, you may see change before there are some new people. It just depends on how it goes. So it can work, yes. Yes, by all means.
Anyway, isn't that one of the aims of the American Constitution Society now that the Legal Defense Fund? Should I repeat that?
No.
Isn't what one of the aims?
Isn't what one of the aims?
To actually influence judges, influence people, build up, as you would say, an abolition-type society that would sort of push these things. I would hope it would be.
Yeah.
Yeah,
as I understand it.
As we understand it, but maybe that's not something, I don't know. Somebody
well,
with society can say that.
It's clearly
it's
one
LDF's function.
One of LDF's thoughts. So, for quite a while,
it's your function.
Many of the people that I'd say are in this room have thought that the most you can hope for is essentially defensive. You can defend against things. And that has caused a lot of folks to sort of lower their aspirations and expectations out of these possibilities. And I'd say we're at a moment where we ought to elevate them. And we ought to see what it is that our country ought to be, and then we ought to figure out a strategy to get there. Because you only have, a limited amount of time to try to take advantage of these possibilities. And that's what the progressive agenda has to be now, how to take advantage of these possibilities. And you have to think out the strategy, figure out how you want to advance it. How do you educate the judges? How do you make those judges educate the other judges? How do you find the evidence? How do you advance it? And what are your goals? So you have to think all of that out. But it's not a defensive agenda. This is, a aggressive agenda to try to do some things that we really ought to get done as a country.
Yes. Someone back there, I can't see who it is. Oh.
Sort of on that note, two quick questions. One, I have been really amazed at how the American people have stepped away from, at least what I understand the Constitution is organized to do, particularly around the idea of the killing of suspects. When I read the newspapers, many times, it will simply say, suspects, they were suspected of blah, 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 they were bombed, they were killed, or whatever. This idea of the killing of suspects, I think, sort of ties into what you're talking about, if I'm understanding it correctly, with the ability to create a new class of person from time to time who has restricted or limited rights that may or may not be protected by whatever is perceived to be law enforcement at the time. Going back to the end of the Civil War, end of Reconstruction, or to our present current date. The question that I have, if we were to take a more proactive view of democracy and freedom, or even better yet, human rights, to say that there are rights that are in fact inalienable to whatever beings we determine to be human, is it possible for us to really rethink our political and legal history so that we are, in fact, able to create another vision of due process that actually works? I hope I'm making my question clear.
Well, I think, I'll see if others want to comment, but I think I understand it. I've been engaged in discussions recently with a number of people about how we should expand our notion when we talk about rights, even domestically, beyond the concept of civil rights, protecting all the kinds of things we were talking about up here, but that there are certain rights that human beings should have just because they're human. And that we should find some way to do it. A lot of this stuff is embodied in UN declarations of rights of various kinds that the United States didn't agree to, or if we did agree to, we don't pay any attention to. But it's a more expansive definition. And many people in the civil rights community are talking now about how we should be discussing human rights. In the book that I showed you, one of the things I talk about is that Obama needs to get a new commission set up, a commission on civil and human rights with a broader mandate, both internationally and domestically, and it's something that Gay McDowell and I have been talking about for years. I don't see Gay. Gay's out there somewhere. Okay. Hey, Gay. And other people. So I understand clearly what you're saying. It goes beyond what we're discussing here, but it's down at the end of the road. I mean, you know, it's further along. It's further on up the road. Yes.
Just to add to that quickly, I mean, I do think that the conversation about human rights has been stalled in this country, and and that progressives in particular have been on their heels responding to the onslaught from the right about the entire notion of protecting human and civil rights under the Constitution being unjustifiable. And that's one of the objectives of the GEM report, and this idea that we should have a privileges or immunities clause, which was designed to be the vehicle by which we protect civil and human rights under the Constitution. And just to go back to John's point, I think it's exactly right that we have been both playing defense, and progressives have not been making claims against the Constitution in the way we should. If all the claims against the Constitution have come from the right, the property rights movement, the guns rights movement, they're all taking pretty flimsy, in some cases, arguments about the Constitution and building a movement around them, which has moved the electorate and moved the debate in this country in their favor in dramatic ways. And I think that's part of what we need to be doing, is figuring out what our strongest claims are, rooted in the Constitution, and advancing them and designing, as John says, long-term efforts to bring those claims to policymakers and bring them to judges of all stripes and make claims against the Constitution, because we have a lot of strong ones.
But, you know, we do have a series of distressing incidents that happen almost regularly where someone who was entirely innocent, in New York last year, it was someone at his wedding, right, going to his wedding, is shot and killed by police officers, and there turn out to be no consequences. We do have a long series of incidents like that, and so I hear the point, you know, that's just unacceptable in our society. I mean, we've got to figure out how we do things that cause that to not happen anymore. But that is something out there that we have to figure out how we deal with it, and it happens quite regularly.
Yeah.
Quite regularly.
We are coming to the end of time, but I will take just this last question. Oh, did somebody else have their hand up?
To go a little bit on that, could you all address the issue in today's context between the difference of the rights of legal resident aliens versus citizens, especially in the context of U.S. entitlement laws?
Did you want to say something?
I don't think we have enough time to cover that, other than what I talked about earlier in terms of that the lines have been blurred, and that non-citizens have, in a sense, facetiously the right to pay taxes and do everything within the government, their rights and responsibilities. And we're now fighting, as I mentioned earlier, the protections for children in the health bill.
I want to give, I didn't see that you were wishing to or wanting to speak, Bill Coleman.
I enjoyed this very much, and I certainly will have to go home and read all this history. But as you work your way through it, please recall that there were 5 cases of the Supreme Court in Brown, and 4 of them had been decided against us. And the only one in our favor was from the state of Delaware. Secondly, that even though we made great progress, there's still instances in which you need some type of court action or government action which favors you. I mean, for example, when I was arguing the Bob Jones case, and on rebuttal, Mr. Justice Powell said, "Do you mean that if you're right, Mr. Coleman, that Smith College could no longer have its exemption?" And I knew his wife was on the board of Smith. So the best answer I could give was, "Mr. Justice, we fought a battle over race. We haven't fought one over sex." And let me get away with that. Secondly, if you look at it, part of what we've been doing in the past is trying to find instances in which you say that based upon what happened in the past, that blacks have just not had the same amount of white, so there has to be affirmative action. And yet, you know, if you take the case of the busing, one of them, where this young kid's family, white, had bought a house right near the best school, and when you tell him he's got to go to the worst school because as a black you go to better school, you got a problem. Well, as I look at it, there are a lot of instances where you have to make a distinction. So don't make this too uncomplicated, because the main thing about a lawyer, he's got to win the case.
Okay, well, we're going to, Bill Coleman, of course, have the last word. We have a lot of work to do, and this discussion tells us how to go about doing some of this work, and we thank you very much for coming.